as a teenager. Immediately suspended from all forms of the game. Bringing the sport into disrepute. Huge fine. He's got it. He's opening the batting for England at Lord's. And for tweets that he posted over 10 years ago. Huge disciplinary action, huge fine. And rightly so. And it sounds harsh, but that is an ongoing publication. Now, some of you may want to be, I'm often asked at the moment, how long do I take, if I've been the victim of some horrible online harm, how long do I have before it's too late to do anything about it? Well, in South Africa, we have 3 years to sue. That's generally the period of prescription. Some things don't prescribe. Murder doesn't prescribe, rape doesn't prescribe, sexual offenses don't prescribe. But for me to sue you for infringing my privacy or for hurting my reputation, I have 3 years from the date of publication. But that's if the newspaper's published today, I have 3 years from today. But if that same article is put online, I have 3 years from the date it's last available, not the date it's first available. Basically, the way the law treats content online is what we call the multiple publications rule. England's just switched to the single publications rule, which means that period runs from the date it's first available. Basically means things don't prescribe. And in the same way, if I Google you and something you posted from over 10 years ago comes up, it's an ongoing publication. How do we do it from a privacy point of view? And I was just thinking about this because I was looking at Ollie Robinson's post. So what I do, and I've seen quite a few sporting people do the same thing, and it becomes relevant when we start talking about privacy in a moment, is I have a private account and I've got a public account. And I'm seeing some of you nod. Like maybe it's a Finsta type account, maybe it's a pseudonym type account, maybe it's like your absolute besties type of account. But I quite like the idea of separating it. Because the content that I'll post on my digital law company account, very different to the content I'll post on my personal account. My children will not feature anywhere on the public account. That's a parent's discretion. You can decide that. But from my point of view, the more you look after your privacy, the more of it you have. The more you look after your children's right to privacy, the more right to privacy they have. This may be worth something to consider, keeping those separate. Let's talk about image-based violence. It happened to Taylor Swift last year. Somebody created a deep-fake pornographic video of her, posted it onto X, onto Twitter. It was viewed 46 million times in 10 minutes. It was, so what Twitter did, I'm going to say Twitter because X is confusing. Elon Musk wants to call everyone X, including his children. So what Twitter did was that they made her name unsearchable. Taylor Swift said she watched this video in the aftermath of this, and she said she couldn't tell it wasn't her. That's how accurate the content is. And I'm afraid we're seeing more and more image-based violence, which is AI generated. So image-based violence is a term that I far prefer to, a lot of people talk about revenge porn, for example. Image-based violence is very often an extension of gender-based violence because women are disproportionately the victims of image-based violence. But what we see is people using your image to cause you harm. It can be you being photoshopped onto a sumo wrestler's body and saying, look at her, she's so fat, how can she possibly play for the national team? Criminal defamation. It can be somebody photoshopping you onto, I use the word Photoshop, we don't use Photoshop anymore, using AI tools to perfectly create a deep fake of you. Now, I'm afraid children are being targeted by this a lot. For those of you who have girl children, you need to talk about this. What you need to understand is that the law doesn't care whether something is real or AI generated. The legal consequences are the same. So, if your child shares a nude of a teen, that's distribution of child pornography. Whether it's a deep fake nude or a real nude, the law and the legal consequences are the same. And there are arrests happening left, right, and center of teenagers involved in the creation of this deep fake content from as young as 12 years old. In South Africa, you have full criminal capacity from 14. That means you can be arrested and charged and sent to prison, no discussion. From 12 years old, and I'm saying this because some of you have children, and so it's always at the forefront of our minds. 12 and 13-year-olds, there's a presumption you don't have capacity to commit a criminal offense, but if you can show that that child goes to a good school, comes from a good family, is old enough to have a phone, then they may well have capacity. So these kind of things are landing up in court more and more frequently. The first case of image-based violence from AI has just been heard in the Pietermaritzburg High Court, and he was sentenced a couple of weeks ago. What happened was he created a deep fake picture of a threesome, and on the face of the one body, he photoshopped the face of Cyril Ramaphosa. Chose the wrong target, because you'll see what happened. The second person, he photoshopped the face of Becky Cele, and then the third person, Becky Cele's wife, right? So sent it around, didn't put it on social media. He was upset because he'd laid a charge of stalking or harassment or something, and he felt like people weren't taking him seriously. So he sent it around. Let me tell you, he was arrested by the Hawks, charged with, and this is where it gets exciting for us, is that I have been working my butt off for years to get these specific laws in place, and we have them now. If any person shares a private sexual photo or video of you without your prior consent, it's a criminal offense, 300,000 Rand fine and 4 years in prison. It's fabulous. So you send a nude to your partner, they share it, 300,000 Rand fine and 4 years in prison. It's great. And as I say, women are disproportionate targets of this, and I get so furious with the victim blaming. Even now in this big case I was just involved in, why are the girls taking the pictures, and the misogyny on the groups, and even coming from the kids, the extremism, the incel culture, the manosphere is really coming through. And so I was just involved in this big case against Meta, but what was happening was these kids were creating these WhatsApp channels, which were getting 50,000 followers within an hour. Is anyone a member of a WhatsApp channel? Anyone follow WhatsApp channels? Anyone not know how WhatsApp channels work? Okay, a few of you. So I'll talk to it a little bit later if I've got time. But they were sharing leaks. So they were soliciting on Instagram leaks of girls. So have you got a nude of a girl? Have you got a sex tape of a girl? Teenagers, mostly. Some were a little younger than that, but mostly teenagers, soliciting the content and then publishing them on these WhatsApp channels. But you've got no idea. The breadth, the extent of the content was unbelievably horrific, right? And the messaging from these platform owners, the channel owners, the admins, was, we haven't done anything wrong. Even when it was reported to them that 2 girls had committed suicide and 1 was in a coma who'd been leaked on these accounts, but we haven't done anything wrong. We're fixing our country. That was the theme. We're fixing our country. We're naming and shaming these sluts. They deserve to be. We haven't done anything wrong. They've done something wrong. And that's from the teenagers. It's like really startling. And so we're seeing, I'm afraid, as I say, a lot more of this image-based violence against girls and against women. So this guy pleaded guilty. Do you know he's been sentenced to 5 years in prison? 5 years. This is a case I was involved in last year where a woman was involved with a guy who was married. She had no idea he was married. He surreptitiously filmed them having sex one night. The wife found out about the affair, and the wife posted it on Facebook. One video on Facebook. And we sued 4 million Rand in damages we got for that case. The tides are turning. The law is there. We can use it. We must use it. And the Cybercrimes Act, disclosure of a data message of an intimate image, again, it doesn't matter whether it's a real image or a fake image. Where I was going to a moment ago with the victim blaming is people saying to me, oh, well, if you take a nude, it's like leaving your wallet on a park bench. Absolute nonsense. If you take a nude and send it to your boyfriend or girlfriend or partner or spouse, it's not like leaving your wallet on a park bench. It's like leaving your wallet on their bedside table and then somebody stealing it. Like, it's ridiculous. The victim blaming that goes on in the digital violence sphere is, I'm afraid, very rampant, even from the police. And then this is the Films and Publications Amendment Act, which I was just telling you about, the 300,000 Rand fine and 4 years in prison. I'm going to skip over that for now. I want to talk about privacy. And I want to talk about this very important case that has just come out of the Constitutional Court. And the case turns on privacy in the digital world. What happened was there was a group of cyclists cycling through a farm in the Eastern Cape. And they stumbled across, they pedaled across the most awful animal abuse. Animals being lured into cages, being left to dehydrate and die. Horrible, horrible, horrible. So the cyclists stop their bikes and take pictures of this awful abuse, get back to town, and they submit them to a guy called Bull Smuts, this guy on the screen, who has a Facebook page called the Landmark Leopard and Predator Project. He publishes these pictures on his page with the farmer's name. The farmer's name is, he's called Herman Botha, right? And alongside these pictures, which is defamation, right? It's saying Herman Botha is guilty of animal cruelty, but you can, provided what you're saying is true and for the benefit of the public, true and public interest. Outing illegal behavior like this animal cruelty, public benefit, right? And it's true. There's the evidence. We don't have to worry about whether or not it's true. There's the footage. Although I do have to just flag that AI world, sometimes you've got to be careful about whether or not something is real. But in this case, it certainly was. Anyway, so he publishes this content, but alongside the content, he publishes 5 pieces of personal information about the farmer. His name, Herman Botha. The name of his farm. His physical address, his cell phone number, and a photograph of him holding his baby daughter. So Herman Botha rushes off to court to get an interdict, which is basically like a court order saying, you naughty boy, you've gone too far, which he gets. And Bull Smuts says, no, you've got this wrong. And he appeals to the Supreme Court and then to the Constitutional Court. And the superior courts find as follows. The test in South Africa for whether or not you have an expectation of privacy is, do you, not as the average person, do you have a reasonable expectation of privacy in a particular set of circumstances? Because if you do and somebody infringes it, you can sue them. It really just means, is this private? If somebody takes a picture of me now, are they infringing my privacy? No, I'm dressed, I'm in a public place, I'm speaking to all of you. That same person comes to my house tonight, takes a picture of me naked in my bedroom. Are they infringing my privacy? Absolutely. Same person, same camera, same subject. Different expectations of privacy. My right to privacy is different to Kate's. Kate's very famous. My right to privacy is different to yours. The more you share about yourself on social media, the less right to privacy you have. So you get to dictate your privacy rights. So they look at this case and they say, okay, Herman Botha, the test here is, do you have an expectation of privacy? And they look at it and they say, no, you don't. Because you yourself have voluntarily put those 5 pieces of information on the internet. His name and his cell phone number was all over the internet, on adverts everywhere you can imagine. He's got a website for the farm with his cell phone number on it, with the address on it. The address of the farm was in Google Maps. And get this, the photograph of him holding his baby daughter was his profile picture on Facebook. Automatically said to public, the court said, but you don't have an expectation of privacy. It's such a good reminder, because I've been shouting from the rooftops for years, the more you look after your privacy, the more of it you have. And it's one of the reasons why I quite like the idea of having a private account and a public account, separating it out. So there we are with the billboard test. Now, we all have the right to freedom of expression. Fundamental constitutional right. But what does it mean? Well, it can be limited in a few circumstances. You know, the world is having this freedom of speech absolutist moment. We've got Trump and Musk at the helm, and they think the right to freedom of speech is more important than any other right. Nonsense. In South Africa, there are all these rights, and we don't have a situation where one right is more important than other rights. My right to freedom of speech has to be balanced against your right to privacy, your right to dignity, your right to equality, your right to religion, your right to reputation. There isn't one right which is more important than the other rights. So the whole thing is a balancing act. So we have these very established laws and rules about where we draw that line. We're going to talk about some more of the laws in a moment. The other time your right to say whatever the hell you like is limited is when it comes into conflict with a professional code of conduct, an ethical obligation, your sporting codes of conduct. Don't bring the sport into disrepute. Don't complain publicly about sporting officials, referees, umpires. It's those kinds of things that you've got to remember that apply not just to you in the real world in the post-match interview, but on social media as well. And when I say social media, I'm also talking about your WhatsApp status, guys. Be careful of WhatsApp status. Folks think that WhatsApp status is like just for my mates. No, no. we treat it legally as if you published it on the front page of the Sunday Times, even if only 3 other people have seen it. So that's the second time. For me, it's the Law Society. Well, now it's called the Legal Practice Council. I can't do anything that would upset the Law Society. Confidentiality, key. You've got to be very careful. You know, you're super excited that you've just signed a sponsorship deal, and you take a picture of it and you're like, woohoo, I'm like major. And then there's confidential information, like how much you're getting paid, or that's a serious breach, right? So just remember, billboard test is always a good place to start. Then we've got contract law. Now, any person here who has a contract with a sponsor, with an employer, independent contractor relationship, you have duties under that contract. Don't bring that organization into disrepute. Don't bite the hand that feeds you. We live in a capitalist world, right? For those of you who have full-time employment, you can't go home and talk about how much you hate your boss and how incompetent your colleagues are, how they couldn't organize a piss-up in a brewery. Even if it's true, you've got all the evidence to show that what you're saying is true. You can't say it because it's not in the best interest of the people who pay you, right? And sometimes that'll feel like censorship. Billboard test is a very good test. Now here's where it gets really interesting. At the ends of my corporate talks, my professional sports people talks, I'm getting asked controversial questions like, what if I want to post about what's going on in Israel and Gaza? I'm very pro-Palestine. I'm very pro-Israel. I'm obsessed with Trump, with Putin. I want to publish every day about how much I love them. I'm very religious. I want to post my religious views. I'm anti-vaxxer. I want to post every day about nobody should get a vaccine. I'm vegan. I think the whole world should be vegan. Fine, provided you don't work for Escort pork sausages. It's a bloody stupid example, but it's a very important one because so often we forget our professional obligations. You may have seen Simone Biles wading in on this trans thing. I mentioned it earlier. And then deleting her Twitter account in the aftermath. There are hot issues out there. And whatever you say, if you are going to wade into controversial waters, my view is quite clear. I just stay out of the controversial stuff. You know, for me, I've got so many different types of clients. There are some things I've got a no line about. Like, if the woman abuse, child abuse, I don't care who I upset. Right? I'm going to be on the right side of history on those things. But some of the more controversial ones, you've got to be careful. This is Israel Folau, Australian rugby player at the time. He posted on Instagram that hell awaits drunks, homosexuals, adulterers, liars, fornicators, thieves, atheists, and idolaters. Now, this is a homophobic post, whatever way you look at it. To this day, he's refused to apologize. He says this is his religious conviction. This is a quote, a direct quote from the Bible he follows, the King James Bible. He's not going to apologize for it. But it so happened that it was totally incompatible with the values and policies of his 2 employers at the time, Rugby Australia and the New South Wales Rugby Union. And he was fired just before the World Cup. Didn't play rugby in the World Cup, won't play rugby for Australia again. So these are the kinds of, when I say we straddle the line, my very firm view is there is no such thing as personal capacity. You are who you are in the real world as online. People who post, oh, I work at Momentum, but I tweet in my personal capacity. There is no such thing. And I've been saying that for a long time, but we finally got a senior court ruling on it. Because what happened was that there was this guy called Mr. Makoba who was working for Clover, factory worker at Clover in KZN, and he didn't have access to any tech. He, as I say, he works in the factory on a Saturday night, outside of work hours, outside of work premises, on his personal Facebook page, from his personal account, no associations to Clover anywhere. He commented, amongst 700 other comments, on an Eyewitness News article in which he said whites must all be killed. Right? By virtue of him commenting, it appeared on one of his colleagues' pages. They sent it to HR, investigation, disciplinary hearing, and he was fired. He took them to the CCMA, then the Labour Court, then the Labour Appeals Court, and he tried to argue 2 things. First, but this was in my personal capacity. Court said there's no such thing. Right? You are who you are in the real world when you go online. And there are manifestations for this with the sport. If we think about what happened with David Teager, who made those comments at the Jewish Achievers Awards, the cricketer, and all the controversy that followed there, and he was like, I'm in my personal capacity. You are who you are, right? The fact that he was the captain of the junior Proteas at the time, he can't wave a magic wand and say, I'm suddenly no longer the captain, right? It does get tricky. But as a rule, You are at all times representing your sponsors, anyone you have a contract with, and indeed the sport. The second thing he tried to argue was the social media policy can't be applied to him because he'd never been trained on it. The court said it's modern day South Africa, you don't need to be taught not to be racist. But a very interesting case. Okay, so those are people messing up on social media, Israel Folau, Mr. Makoba. But then we have people messing up in the real world. People like this. So this was on Boxing Day. Nobuntu Mkhize, she was drunk on an aeroplane, behaved very, very badly. It's resulted in all sorts of criminal charges. You know what one of my favorite things is? You get in that seat, and then they say, please consider the privacy of the passengers around you. Nobody is allowed to take pictures of anybody else, including the staff. And I'm like, every single person on this plane was filming. Like every single one. Anything goes wrong and people film. And it's fair enough, because if we go back to what I was saying about privacy, the more you look after your privacy, the more of it you have, right? You have a reasonable expectation of privacy. As I say, at a Coldplay concert, you don't have an expectation of privacy. You're watching the Springboks and Supersport's pans over your face. You can't sue Supersport for infringing your privacy, right? You have no expectation of privacy in that moment. As I say, the more you look after your privacy, the more of it you have. The more you look after your children's right to privacy, the more right to privacy they have. And if we speak to the sporting example, for those of you with children, quickly on the sharenting issue, I was thinking about it because I'm sure a lot of you have read Andre Agassi's book. It's brilliant, sports autobiography. Anyway, so I finished reading it and I think to myself, oh, I wonder what Andre Agassi and Steffi Graf's children look like. So I go and I Google, not a single picture of them on the internet. Nothing, gone, nothing. It means that if there's ever a family photo taken, the faces of the children would have to be blurred if it was published anyway. Despite their immense fame, they've managed to create expectations of privacy for their children. That's their discretion, they can do that. If you compare it to the way Serena Williams handles things, the GOAT, right? She has her first daughter, it's very unusual because she's got different approaches to the two children, but the first daughter, Olympia, had her own Instagram account when she was in utero. Literally, when she was still in Serena Williams' tummy, she had her own Instagram account. She's got her own Instagram account with 1 million followers. If the tabloid magazine publishes a picture of the kid watching her mum play tennis, she can't turn around and say, oh, but I'm going to sue you for infringing my child's privacy. What privacy? Do you see what I mean? Like, you get to dictate your right, your legal right to privacy. But there are two defenses to a privacy infringement. The first is consent. You can publish my HIV status, I give you permission. You can publish my home address, my cell phone number, how much money I have in the bank account. I give you permission. Consent is the first defense. The second defense is public benefit. As I said earlier, you do something illegal, your privacy falls out the window. You guys know who Babes Wodumo is? Quite a okay, so Babes, silly question. So Babes, when she was dating Mampicha, who she later got engaged to, then married, and he died. It was when they were dating, and she went live on Instagram at midnight on a Sunday night. And it showed her boyfriend at the time, Mampicha, in his underpants, in his bedroom, which was a hotel room actually, I think, midnight on a Sunday night. Does he have a reasonable, legitimate expectation of privacy in that moment? Absolutely yes, but he was beating the hell out of that woman. It was a domestic violence, gender-based violence attack. He can't come forward and say, oh, but what about my privacy? What privacy? You do something illegal, your privacy falls out the window. Does that make sense? Okay, good. Okay, so same thing here. Privacy fall out the window. I'm going to zoom over a little bit of this, but this has also affected sports people. Alton Yankees, who also behaved so badly on an aeroplane. This is the kind of person sponsors don't want to get involved with, right? And it's not messing up on social media, again, it's often messing up in the real world, documented and put on social media. We don't have time to go through these in too much detail. I've spoken about quite a few of them, but I do want to quickly touch on influencer law, because even in the earlier questions, we're going to start our side hustles. Side hustles are awesome. For those of you who have full-time employment, please make sure that your employer is aware and has given you permission for whatever side hustle you might have. All the corporates I'm going into at the moment, they're saying to me, can you talk about the side hustle? Because you have like trainee lawyers or young accountants or whatever starting in companies, and then they're making the TikToks of like day in the life of a corporate hun, and then there's me, and there's me in the lift, and there's me like rolling up. Now, any of us in this room who've made content, you know how long it takes, right? Like, you're not doing your work if you're spending 6 hours a day making your TikToks. Also, it may not align. You know, maybe you have a side hustle where you're sponsored by a protein brand, which is in conflict with the protein brand that sponsors your team. You know, just bear all those kinds of things in mind. Now, the Advertising Regulatory Board is now finally clamping down a little bit when it comes to influencers. And it's right, because if I'm watching Instagram or TikTok and somebody tells me this is the best mascara in the world, I want to know, is it the best mascara in the world, or is somebody paying you to tell me that this is the best mascara in the world? Like, we need to know what is organic and what is sponsored. So, Appendix K, for all of you influencers, listen carefully. Appendix K of the Advertising Regulatory Board's Code of Conduct governs influencer marketing. I can summarize it as follows. As follows. There are 2 requirements. The first is you have to have a contract, a written contract. Details of the brief, how much money is going to be paid. We're not just talking about money. Come on this fabulous holiday and post about how amazing it is. It doesn't have to be a fancy contract. It just needs to be in writing. And mandatory disclosures. So particularly if you're involved, maybe it's a gambling thing or lotto or any kind of mandatory disclosure that would be required in mainstream advertising would have to be included in your social media advertising as well. And then the second requirement, and I'm summarizing, it's quite a long document, but the contract, and you have to disclose that it is sponsored. You have to say paid partnership with. They talk about the recognized identifiers, hashtag ad, hashtag sponsored. If it's a product drop, for me it's enough to say, oh, the nice people at Clarence dropped off some cream for me, fine. But I do think you've always got to disclose. I think it's just part of like the legitimacy of it. Not just that I think, you have actually, it's a legal requirement now. This was one of the first cases. Volvo South Africa gave a YouTuber called Candy Kane a car to drive for the weekend, which she did, and she posted these YouTube videos, which was the arrangement, but she didn't disclose that she'd been given the car for free. And so they ruled against her at the ARB. This is a very interesting influencer case. It involves a university student in Pretoria, a micro-blogger, a micro-influencer, right? Who's a TikToker, who enters into an arrangement with a contract with Native Child, right? And her job is to post about how fabulous the products are. And she does that. In the contract, there's a sliding scale of remuneration. If your TikTok gets this level of engagement, you get paid X. If it gets 2X engagement, you get paid 2X, right? We've seen those kind of contracts. Mm-hmm. So she posts, crickets. Nothing. Nothing happens, right? So she gets paid on the smallest scale. At which point, in an attempt to extort Native Child, she starts a campaign about how Native Child doesn't pay their influencers. That gets traction. Huge, viral, right? People are boycotting Native Child because they're such a terrible, unethical company that don't pay their influencers. So they went to the urgent High Court. It was over Christmas, over December. And they got an order against her. She had to apologize, retract, etc. Then she had to pay damages. Then she had to pay their legal costs on an attorney-client scale. Yeah. Anybody who's had anything to do with litigation knows that that's at least a 500,000 rand check, right? She's a university student. And it was malicious, right? Like she really thought if she could put pressure on them, they'd pay her more to go away. Don't be that guy. I wanted to talk about celebrity image, all of these memes that are going around. You know, there's a lot, especially going on with AI and image-based violence about the right to celebrity image. Now, we can all thank my friend Basitsana Kumalo for creating, a long time ago, the right to celebrity image in South Africa. Denmark, you might have seen last week, announced that they're going to give every citizen of Denmark copyright over their face and their features to guard against all the deep fakes, right? We have it in South Africa. Years ago, Bassi went to the Cycle Lab and She had just had a baby, she wanted to lose baby weight, she was going to take up cycling. She tries on a helmet, and do they take a photo of her? And do they use it in their advertising? Right? So she sues. And that was the case that established that in South Africa we have the right to image. Right? People cannot make money out of your image unless you consent or they pay you. Both of those things, ideally, actually. She said it was the most unflattering picture of her that had ever been made public, etc., etc., and like, basically, how dare they? And that is right. The deepfakes, we see it, people using your image to market cryptocurrency. I had this case with Lynette and Thuli. I've had so many. Lyra, last year, just before the election, somebody using deepfake technology made a video of Lyra, you know the singer Lyra, right? She's fabulous, endorsing the MK party. Like saying the MK party is the way, guys. This is what you're going to be. Obviously not like that. That's not. And posted it to their official account. And we take legal action in that case. We reported it to the Independent Electoral Commission. We can take legal action. This is a professor of urology at Steve Biko Academic Hospital in Pretoria, and they used her image in publicly available videos. And I'm afraid this is going to happen to all of you in the public eye, which is also why we need to be able to immediately take to our own social media channels and say, I'm aware of these deepfakes circulating. It's not me. And then we can also, as far as possible, track and trace, find out who's behind the content, and take legal action against them. But this woman was the victim of this image-based violence in the form that they took her picture, took a readily available video, and turned her into a deepfake endorsing some fake Viagra type product, like a men's virility product. It's saying, oh, don't use any of the FDA approved products, they're very dangerous. And so a huge defamation element as well, and successful. Let's talk about this, Jackie Pomotse. So she makes this book. She doesn't make a book, she writes a book. It's called I Tweet What I Like. Oh, so sue me. So we did. This is the backstory. Jackie Pomotse, 5 years ago, tweeted that she had just watched a video of a celebrity man performing a sexual act, a rim job, excuse my language, but it's in the tweet, on an underage boy, while his drunk media mogul wife looked on. Didn't name them, but remember what I said a moment ago about indirect reference. Everyone. Are you talking about Basi Kumalo and Romeo Kumalo? And she's sometimes responding with like a laughing emoji or whatever, or hearting, but doesn't confirm or deny officially. So Basi, and to their credit, with all their millions of rands, they could have rushed off to court, briefed the most expensive advocates, etc., and got a high court interdict. But they used the law that's available to all of us. They laid a criminal charge, in those cases criminal defamation, that's off our books now, but crimininjuria, same thing. And they got a protection order against her under the Protection from Harassment Act. That might be the most important piece of law in your future, guys. The Protection from Harassment Act allows you to get a protection order against somebody who is threatening you, harassing you, stalking you, bullying you. They actually call it the cyberbullying law because they talk about this harassment in the real world and specifically online harassment. Trolls are horrible, right? Sometimes you can block them, but sometimes they don't go away. And if that's the case, then you go to the magistrate's court, you don't need a lawyer, you don't need money, you go to the magistrate's court, you explain how you're being harassed, and they will give you an interim protection order. You have to show harm or a fear of harm. It could be mental, emotional, psychological harm, or a fear of that harm. They will give you that protection order, and then there's a return day. It's made permanent for 5 years. Brent Lindeque, the Good Things guys, just obtained one against an anonymous person. All stopped immediately. Anyway, so she gets this protection order, it's made final, and then does Madol write a book with the case number of the protection order on the front cover. So then we're back to court on a contempt charge, which she gets found guilty of, and then she was fined. A 32,000 Rand fine, she got 16 hours of community service, she got 2 years of house arrest. So she's under house arrest at the moment. It did take a long time, but a very, very important case. And as I say, I'm glad they use the laws, the rules that are available to all of us, including our teenage girls, because often where those teenage girls feel like there's absolutely no help, hope available, if we can filter this message down, and this is my plea to people like you who have influence, to look after your rights, because it means that we're making the world a better place for our teenage girls. Okay, so there are lots of new interesting cases. This is a defamation case. Somebody on Twitter posted that Hank's Old Irish Pub was racist because they had a racist dog policy. It was nonsense. The kid's just been ordered to pay 1.25 million rand in damages, plus the legal costs. This was the Brent Lindeque case I was telling you about. Musa Kawula, we know about, been in prison for a long time. We're seeing much bigger fines. I think that, we're talking about reputation in this session. I think that we're seeing suddenly, like the Hank's Old Irish Pub case, it used to be at best you'd get 50,000 rand in damages. Now we're looking at much, much bigger than that, right? Which is good, because I think it's an acknowledgement from our judiciary of how important reputation is in the digital age. Reputation is everything in the digital age. This guy's just been fined 500,000 rand for use of the K word. You'll remember this case against, what's his name again? What's his nickname? Grootman, thank you. Yeah, Grootman leaked a sex tape, and she went off, got an interdict. There are criminal charges pending, damages claims pending. They're going to be big, right? But my favorite thing was she served it to him over Instagram. So she went off, got the court order, which says that the respondent, that's Grootman, is interdicted and restrained from posting or publishing photos or video, publishing, disseminating the sex tapes, etc. And then she says, she posts the order and she says, take note. I loved it. Okay, don't think you're anonymous online. Be careful of emojis. Emoji is just another way to communicate. In Canada last year, they found that this is a very, very interesting case, but I am a law nerd. But basically they found that a valid, legally binding contract had been concluded via the sending of one emoji. What happened was that there was this farmer who was approached by a grain dealer. Can we buy a certain amount of grain from you? In this case it was flaxseed. So the guy said, sure, I've got it, send me the contract. He sends the contract, he replies with one emoji. Then the price of flax went through the roof. He tried to extricate himself from the deal. The guy rushed off to court, and the court found a valid, legally binding contract had been concluded by the sending of that one emoji. This poor woman who had to sit on the stand for a couple of days explaining about eggplant emojis to people who did not understand what eggplant emojis were. Sexual harassment can come in the form of an emoji. A death threat written in emoji is still a death threat. I am an expert witness in a case coming up. It's a very important high-profile case on whether we can send somebody to prison for the use of emojis. Of course we can. Let me tell you quickly this case. It involved a case in New Zealand, and there was a woman living in the North Island. She was in a horribly abusive relationship, and she eventually left him, packed up her stuff, got a protection order against him, and moved to the South Island. Blocked him on WhatsApp. She then received a Facebook message from him, which had only 3 emojis. An aeroplane emoji, a fist pump emoji, in this case, very clearly a punch, and an ambulance. That was it, 3 emojis. Took it to the police, arrested, violation of the protection order. Okay, so I'm going to just quickly show you some of the crimen injuria cases. This guy's just been found guilty of crimen injuria. He tweeted to the South African Jewish Board of Deputies, the Holocaust will be like a picnic when we're done with all you Zionist bastards. Beep all of you. Found guilty of crimen injuria, infringement of dignity, 28,000 rand fine, a 5-year suspended prison sentence, and a criminal record. A criminal record sucks, guys. We know about Vicky Momberg, a racism case. This was an interesting case because it shows you how we can use crimen injuria in bullying cases. This is Joyce Malawi. She posted about Uyanda Mbuli. She said on Facebook that Uyanda Mbuli was a stupid B, word beginning with B and ending in itch. And then she posted Uyanda Mbuli's cell phone number and she said, please can somebody go and find her a blesser so she stops phoning my boyfriend asking him for money. She had been phoning the boyfriend asking him for money. He owed her money. She thought better of it and she deleted it quite quickly. Doesn't matter, once it's out there, it's out there. Digital content is dangerous content. Uyanda Mbuli's got her receipts. She takes the screenshot to the Midrand police station, lays 2 charges of crimen injuria against her. She gets found guilty. This was her sentence. It's one of my favorite sentences. 6,000 rand fine or a suspended 4-month prison sentence. 350 hours of community service. That's actually quite a lot, guys. She had to attend an 8-week adult life skills program through NICRO, like a program for adulting. Who knew? But more serious than that was that she was studying law. She now has a criminal record for a Facebook status in the heat of the moment, which she deleted very quickly. Guys, I think you've got it. I think that you understand the billboard test is the bottom line. Disciplinary stuff, ethical obligations, confidentiality obligations. I know it feels like I'm like, oh, don't use social media. I'm not. That's not where I am. Where I am is, it's not a question of whether we use social media. The question is how well we do it, right? For us as professionals, as professional women, you know, and I'll just quickly finish by telling you my own story, which is when I resigned I was at a big law firm. I was at Webber Wentzel. And I decided that I wanted to go on my own and do this kind of work. And I resigned, and the senior partner came to speak to me. And I say that with such, because it's like 700 lawyers there, right? And he came to my office and he said, I believe you're leaving, and your plan is to start your own thing. And are you mad, basically? Like, how are you going to make money? How are you going to get clients? Like, have you thought this through? And I said in my sweetest voice, well, if it doesn't work, I'd be very grateful if you take me back. And I thankfully have never had to make that call. I've been busy every single day since I started my business. I've never spent 1 cent on advertising or marketing. I've styled myself as the expert on social media law on the continent, and that has solely been through social media. Social media is unbelievable if you get it right. If you get it wrong, not so good. Thank you very much for having me.
Our legal eagle, ladies and gentlemen, Emma said, I give her a round of applause one more time. We are so glad you were crazy enough to leave, because you wouldn't be here. Probably. Quick question. How many of you are scared now to be admins as well? WhatsApp? I mean, I think I'm exiting all the groups that I'm in charge of. Yeah? Okay, no.